Okay, so here we are. We're talking about the ins and outs of commercial transactions. So as I said, there are a lot of different types of commercial transactions. Um, it covers a broad expanse of transactions. You can have single family units that are purchased by an investor. And that's mostly what you all would see on a regular basis, right? You have a client, they decide, maybe I'll buy a condo and keep it for, and use it as a rental property. Or then maybe they're moving out of their townhouse and buying a single family home, and they want to keep that, property as an investment property, right? So that's, the first level of what you would see as far as a commercial real estate transaction is concerned. It's technically commercial real estate, right? Because it is an investor, but the documents and such that you will use will be your typical residential real estate contract. So we'll get into that more in a moment. Then you'll see, a multifamily unit building purchase. It might be a duplex, or it might be a small 4-unit, or, it could be, a 15-unit apartment building. So anyway, so that's when you start to get a little bit more involved in the transaction, right? We start to see lawyers, we start to see due diligence periods. The underwriting of the loan is different. So the lender is much more involved with the lawyers. So that's taking that investment property up another unit. Next, we have, an office or a retail lease. And that's another way that a lot of residential agents kind of start dipping their toe into the commercial real estate market, right? You have, a friend or again, a past client who is maybe leasing some small office space and wants you to help them with the lease. Or, they're opening a little restaurant or a little storefront. And again, they want you to help find the space and review the lease for them. Then again, and that's, relatively straightforward. We're going to go into all of these categories in a little bit more detail, but I'm just kind of giving an overview right now. So the next then, as we keep building out, would be a commercial building purchase. Okay, someone's going to buy the entire building. There might be office units, there might be residential units. It might be mixed use with commercial on the first floor and then apartments above it. So that's when you really do start to get into, full on. You're going full on with the lawyers and everybody on the commercial building purchase. And then finally, vacant land purchases. The vacant land purchases can be considered a commercial real estate purchase, depending on what the purchaser is using that property for. And then that, has a whole myriad of, it's a different type of contract. There are different types of due diligence, going on with that and different issues to look for. So, that's kind of an overview of the categories of commercial real estate transactions that you would typically encounter as a residential agent crossing over into commercial real estate, or as a residential agent who, is asked questions about commercial real estate by people who might be interested in pursuing a transaction on one of these categories of items. So our local jurisdictions do not require a separate real estate license to sell commercial real estate. There's no requirement at all. Some people think that there is. Now, individual brokerages, on the other hand, may have requirements. For example, when I was an agent, I started with Coldwell Banker and wanted to do commercial deals and had a strong background in it from a legal perspective. So I had to get special permission from Coldwell Banker to be able to participate in commercial transactions. Again, no special licensing from the state of Maryland. There's not a commercial real estate license, but I had to get special permission from my brokerage to be able to handle those transactions. Now, there's all sorts of continuing education and certification courses and things like that on commercial real estate. You might be able to get a commercial real estate designation. But again, there's no formal license to sell commercial real estate in the state of Maryland. Okay, so let's look at the different types of deals that we have here that fall into commercial real estate, right? Actually, let me see if we have any questions before I keep going here. Let's see, Sarah's given us mastermind. Okay, I don't see any other questions, so let me keep going here. All right, so again, the first type of deal that we have is, the purchase of a single family residential unit for use as an investment property. Okay, this is treated as a standard residential real estate transaction. There's no special checklist needed, no special contract form. You treat it as just a regular residential purchase. You're using your regular residential contract, and you're going from there. Typically, there's no lawyers involved. You're using your same lenders, except now they're running the property through underwriting as an investment property as opposed to a primary residence. So pretty straightforward. A couple of points to note here is that once you start getting into single family units being purchased for or as investment property, now you're starting to get into a situation where you might have someone buying the property and in an LLC, in the name of an LLC, or in a partnership. So this is the time when it's important to understand some of the differences amongst the different types of entities, what the documents are, and so forth. Not because you need to do a deep dive into entity formation or know as much as a corporate real estate lawyer does, but just again, so that you're knowledgeable, so that you can prepare your clients for what they're going to need in, to provide the title, or if you're advising them, if they're at the beginning of their search for a property to purchase, you can advise them like, okay, well, you're going to need to have these items ready because title is going to need them. And, if it's a newly formed entity, or maybe it's an old entity that they haven't been using and now is not in good standing with the local, with whatever jurisdiction they filed in because they owe back taxes or something like that, it gives them time to get everything cleaned up before we actually get to closing. So let's take a moment and look at our entity types here. So here's a little cheat sheet, and I will send you guys this, some of these little cheat sheets after the class so you have them for yourself. So, so here are the three basic types of entities you're going to come across. The most common in your world and for people purchasing investment property is going to be a limited liability company, an LLC. Super easy to form. You don't need a lawyer to do it. People can just file with the local corporations commissions or in Maryland State Department of Assessments and Taxation. And it's a form. There's forms online that you can just fill out to create your LLC and file it, right? And that's called your articles of organization. Sometimes you'll see it called a certificate of formation, and that's what creates the LLC. Okay. The operating agreement, which is the third item down on my little list here, the operating agreement is what controls the LLC. So, title for sure will ask for a copy of the operating agreement as well, because that's where we look to see who has authority to sign on behalf of the LLC, who has the authority to enter into contracts and make the decision to even purchase the property or take out a mortgage. Now, you'll find, particularly for people who, this is a one-off and they just are throwing it into an LLC just because, or it's a single member LLC, so it's not super complicated. They might not have an operating agreement, and that's fine because there are statutes available in all of the states that tell you if there's no operating agreement, how does the LLC operate? Okay. So you have your articles of organization that creates your LLC, and then you have your operating agreement that controls your LLC. Next, you have a certificate or evidence of good standing for the LLC. And that's an important one. And that's something you can look up online yourself. What that tells you is that the company is seen as the state as a legitimate operation. It's been, created correctly. There aren't any overdue filings, whether it's personal property tax filings or anything else related to that company that's due with the state. And so then, you have a valid LLC that can go forth with the transaction. And title reviews all of, reviews these entity documents to make sure everything is all clear. But again, to be able to prepare your clients or know the terminology if people start talking to you about entity formation, or usually what people say is, I think I want to put my property in an LLC. What do you think? Okay, so that's the structure for an LLC. Now you see the last thing on this list here are borrowing or purchase or sale resolutions. And this particularly is important when you have more than one member in the LLC, right? And this is getting a little deep dive, but I think it's important to kind of understand the whole spectrum of what's going on with these entities. So the borrowing resolutions or the sale resolutions, they let us know that the company has officially sanctioned the transaction to happen. So let me show you an example of an LLC resolution. This is just a blank form, so it's not super great, but this is what it looks like.
Sorry, Heather, I don't think we're seeing your pages. We're still seeing the summary and overview page.
Oh no. Hold on. Oh my goodness. Okay.
Sometimes you gotta unshare and then share again for you to be able to see something different.
Can you see it now?
Here we go.
Yes, thank you.
Okay. So anyway, so you see here, it's nothing earth shattering. It's just my small list here. Okay. Again, we have a limited liability company, articles of organization, a certificate of good standing, the operating agreement, and now we're talking about the resolutions. And let me go ahead and share the resolutions with you. All right, can everyone see resolutions?
Yep.
Okay, perfect. Thank you. Perfect. All right. So what we have here is just a form of a resolution, and they're very simple, and they're typically used when, again, when you have more than one member of a company, right? So it just says, I, Joe Smith, certify that I'm the managing member of, or the authorized member, or whatever they call themselves in their company, allowed to act on behalf of the company, organized under the laws of the state of Maryland or DC or Virginia, and that they had a meeting, or if they're, again, this gets kind of in the weeds, but they can act without a meeting, whatever, that they agree to the following. And then you see here, it's resolved that the LLC has entered into or will enter into, a purchase and sale agreement for the purchase of real property is typically something you would see here. Okay. And then, it could be resolved that in accordance with the transaction, which will be up here, the authorized member can sign loan documents or any other documents necessary to complete the purchase of the property. And that's it. It's usually just a one-pager. Depending on what their operating agreement says, it may be signed by different people, but it's a signed authorization for us to know that the company has followed their procedures for permission to enter into the transaction, and they're clear on who's signing and they're confirming who's signing. So that way you don't have any confusion, right? And later on, if someone comes back and says, someone else in the company comes back and says, wait, we never authorized this transaction, this is the evidence that they are authorizing the transaction. Okay, so I just kind of wanted to show you what a resolution looks like because they get asked for. And some commercial lenders, especially if it's like a small business lender, they'll actually include a resolution in the loan package. But I think it's always good to have a visual of what it looks like here. All right. Any questions about resolutions or LLCs so far?
Some of the points to make is that this resolution, the only thing is we usually have to look at the operating agreement in order to be able to know who needs to sign, what needs to happen.
Correct.
So to Heather's point, a lot of the times, people are getting into the whole thing of buying commercial properties, especially with 1031, especially now that we're seeing like the tax liabilities, and they don't have all their paperwork ready. So this is just a reminder that if you have a buyer who's looking at it, Heather or I can always take a look at their operating agreement, make sure that their LLCs are active or their entities are active, and they have the appropriate documentation to make everything as simple as possible.
Absolutely. Absolutely. And that's the point of having this discussion right here is, again, just to prepare your clients. I wouldn't expect an agent, and I certainly wouldn't want you to be a party to unauthorized practice of law or anything like that. But like I said, knowledge is power, and I want you to be able to have like a meaningful conversation with clients about the situations that arise in these types of transactions. Very quickly, you can see on this same list, we have a partnership. The structure is very similar. A partnership is formed by filing a certificate of partnership with the state that the partnership is being formed in. You have a partnership agreement. Sometimes it'll be a limited partnership agreement, a general partnership agreement, but there's an agreement that governs how that partnership is going to be operated. Again, you can get a certificate of good standing from the state that it's been formed in, and then also resolutions of the partners. And then a corporation, same situation. The articles of incorporation form the corporation and are filed with the state. The bylaws are the governing provisions that control how the corporation is to be run. You have your certificate of good standing again, and then you have your resolutions. So the structure follows the same as far as forming, governing, finding out the standing of the entity, and then the resolutions, right? It just matters. They're just the nomenclature is just slightly different, but based upon what type of entity it is. All right, so let's go back to our original screen. And if anyone has any questions on that while I'm swapping over, pop them in the chat. All right, let's go back to our summary sheet here. All right, can everyone see the summary? Go with yes. Okay, so here we have our summary again. So we talked about what happens with single family units. And then we talked about entities, since this is the first time that you may see an LLC buying a property. Okay. So next we have our multifamily buildings, right? And again, this could be, this here. This can be, again, a duplex. It could be, a 4-unit building. And so depending on the number of units in the building, it may be treated as a standard residential real estate transaction, or it might then go to the next level where it's really a full commercial transaction, right? And so here are the important things you need to know about that. Again, it depends on the number of units. So if it's just a duplex that's for sale, listed as a residential property, you can go ahead and just treat it like you would any other property. Yep, Hillary says anything over 4 is treated over commercial. Absolutely. But I've seen some situations where, depending on how sophisticated the seller is, and how big their portfolios and things like that, sometimes I see smaller properties treated as a commercial deal. So again, 4 and up is definitely a commercial transaction. Under 4, it could go either way. So some important points to note here, if you're doing a multifamily building, again, you're at this point, your parties to the sale are very likely to be entities on both ends. I can't imagine someone buying a multifamily building in their individual name. So you're going to have the entities as your parties to the contract. Okay. You'll now have probably a lender-driven due diligence process, right? So the lender has, their underwriting on the property is much more substantial, and they'll have a list of items that they want to review. They'll want to review title like they do in a commercial or in a residential transaction, but it does get to be a little bit more, it's a little bit deeper. In commercial real estate, depending on where it's located, can have more easement issues, and just, you're starting to look at zoning issues and things like that. So the lender has a lot more that they're looking at. So they are looking at, they really drive the due diligence process on this. They'll want to see the entity documents of the borrower, things like that. And again, depending on the size of the property, there may be an attorney representing your client who will then get involved in the transaction on behalf of the parties, right? So what does that mean? So if you're an agent in a commercial transaction that's a little bit bigger, and your client has an attorney, that attorney might be drafting the contract, and in most cases will be drafting the contract. That attorney will be kind of quarterbacking the situation and coordinating with the lender on due diligence. And again, this is the buyer's attorney, who's usually, at least in my experience, is usually driving the ship, right? So they're coordinating the lender, they're going back and forth to you as the agent to confirm business terms, or if there's a business portion of the transaction that pops up. And then depending again on the size of the building and the property, you'll have other outside players, right? Like you may have a surveyor involved in this, and it's a different thing. You may have an environmental company coming out to the property to do what's called a phase 1 study, which is a real simple, or the base level study of the property, doing soil samples and things like that. Checking if there's an underground oil tank on the property, working with the state to get the appropriate documentation. So you may be thinking to yourself, well, if the attorney is drafting the document and working with the lender to drive, the due diligence and any kind of property review and inspection prior to closing on the transaction, what do I do? What do I do as the agent? Am I just showing him property and that's it? And no, that's not it. You are, your primary responsibility is locating that property for them and working out the business terms of the transaction, right? Price, inspection periods, which will be longer in a commercial transaction than they are in a residential transaction. Read back if there's existing leases, if the building's being taken to the leases or not, depending again on the type of transaction. And then to start the transaction, right, to make the offer, you're going to write a letter of intent. That letter of intent is non-binding. So it may look like a contract and taste like a contract, but it is not a contract. It is a non-binding agreement between the parties as to what the terms of the contract are going to be. Okay. So you as the agent would write the letter of intent to the seller and the seller's agent with these preliminary offer terms, right? And it's kind of just a bullet pointed letter in most instances with, okay, here are the terms my client wants the property on, here's the purchase price, here's the closing date, here are the basic terms that we would like to see the deal work on. And so then you send that to the seller and the listing agent. They'll look at it, say yay or nay. If they say yay, they'll countersign it, send it back to you. And so at that point, then that's what's given to the lawyers to draft the contract on. The lawyers then, again, business terms, lawyers typically go back to the agents and say, all right, they're now saying they want a different price point, or they want a credit, or, the typical pricing kind of business things that come up in a transaction. So the lawyer will still look to you for that type of scenario, but the lawyer's drafting all the legalese and, all the terms for the transaction. I think I have a question. Is the letter of intent non-binding even if it has been signed? Yes, it is. So what does that mean, right? You have this signed agreement. And it's basically an agreement to enter into a contract, right? But it's not a contract. So what does that mean? It means the seller can enter into a contract with someone else, even though you have a signed letter of intent, until you have that ratified contract where all the contract terms have been fully negotiated and both parties have signed the contract. The transaction as a whole is not set in stone. Okay, so the countersigned and accepted letter of intent is, a great moment, but until you have that signed contract, you still are a bit hesitant in your celebrations. And until you surpass any due diligence period and make it through all the inspections, then you're really, then you really can't celebrate until after that point. Okay, so I've mentioned due diligence a few times. So let me show you a sample of a due diligence checklist here. And let me get back into my share and pop up a due diligence checklist for you. Now, this is just a very stereotypical list. It is, it can be a little overwhelming, but it gives you an idea of what's looked for during a due diligence period and with in a commercial transaction, right? So they're going to look, the seller is going to have to provide basically all of the historical documents that they may have for the property, right? We need this, you want the seller's title policy. Again, depending on the type of transaction or the size of the transaction, there may be a new Alta survey drafted, which is much more expansive than a location drawing or even a boundary survey. Alta surveys can get expensive, but in most commercial transactions, they get, they're necessary. In most cases, the lender will require it. But also you're going to want the seller to provide you with any Alta survey that they have, as well as certificates of occupancy and drawings and, anything like that. Depending on what is going into the property, maybe you might need to confirm the zoning or know the zoning, which is important as an agent when you're showing them showing your client property, right? Because if your client wants to open a restaurant, right, you don't want to show them property, even if it's deemed commercial property, in a location where they can't operate a restaurant. Right. So that's an important thing that you would need to know as a commercial agent, is making sure you're showing your client property, or at least throwing that caveat out there that, hey, here's this property. It looks like it's going to suit your needs, but you'll need to confirm the zoning. Okay. And put that responsibility on back on your client or on the lawyers. Okay. They want to see, financial statements from the landlord, seeing if what's the property doing. Rental properties, you'll want a rent roll from the seller, right? Which is not just a list of the leases, but it's a list of the leases, their security deposit amounts, the commencement date of the lease, the termination date of the lease, any delinquencies, things like that. And it's typically certified by their property manager if they have one. Okay. And then, any personal property insurance policies, any pending litigation, all of that should be listed out by the seller and provided. to the buyer. And again, this is what typically the lawyers, right, ask for and review in a commercial transaction. But again, if you're working with a seller who's going to be listing commercial property or a property that's available for commercial use, as you're preparing that listing, you may want to advise them like, hey, to the extent you have these items, get them together because your buyer is going to want to see them. Okay. And if it really, if you have a client, a commercial seller who, is like, I don't want to provide that, it's confidential. Well, then typically what happens is the parties enter into a confidentiality agreement. And it's pretty straightforward. Okay. So that's what a typical due diligence checklist looks like. Any questions on this point? Or on due diligence or anything we've talked about so far? All right. So we've talked a bit about multifamily buildings. Next, we have office and retail leases. Office and retail and any kind of commercial lease, it really runs the gamut. And I would say, hold on, let me see if I think I have a question here. Yes, I will send you guys a copy of that checklist after class. So going back to leases here, really, commercial leases run the gamut. Some are horrible. They are 2 pages long. There's, other than not waiving your right to anything provided to someone by law, it's kind of the Wild West as far as what a lease can look like. I've seen 2-pagers that are terrible and barely say anything more than, here's how much rent is, here's the address of the property, here's what the security deposit is, and here's when the lease terminates. To, when I first started my legal career, I did a lot of commercial leasing work. And, they were leases with Target and Old Navy and things like that. And those leases can be, 50 pages and make you cross your eyes because they're so, like, you're reading them and they're just so boring and so much legalese. And I find that what drives the level of, what that lease is really the sophistication of the landlord. And if the landlord has, a good property manager or a good lawyer, because at that point, the landlord is vetting the tenant more than the tenant is vetting the landlord, right? So when you have someone who's purchasing a multifamily building, right, it's the landlord's business as well as the property that's under scrutiny, so that your client, the buyer, knows if it's a worthwhile investment or not. But then you have, in leasing, it's the opposite, right? The landlord is now vetting the tenant or your tenant client to make sure that they'll be able to pay their rent, their business is viable, and they're not going to go out of business in 6 months, leaving the landlord with an empty space. So the landlord's sophistication tends to drive the lease negotiation and signing process. With leases, and again, depending on how sophisticated they are, you might be, drafting, you might be filling in the blanks on a form of a commercial lease that your brokerage has in dotloop. You might just be doing a letter of intent situation and then having an attorney draft the lease. It really depends on the sophistication of the parties. Let's see here. The last one right here. So, with the commercial leases, it depends on the sophistication, but the points to note in a commercial lease are, again, you're likely going to have entity parties. Sometimes not if it's just a small commercial building. I used to see a lot in Baltimore County where, like, it might be a little house along Route 40 that's being, leased out to an insurance company to use as their office. And that, might have an individual landlord and, the insurance company LLC or insurance agents LLC is the tenant, and it might only be a few pages long and there's no real involvement from anyone else, to a situation where it's maybe a location in a strip center, or the ground floor of a multi-use building. So again, you're going to see entity parties. Something you're going to see in leases, in commercial leases, that you don't typically see elsewhere is the build out, the tenant's build out. And that's one of those things, again, depending on the situation, that can be negotiated. It's, how much is the landlord going to contribute to the build out or the configuration or the finishing of the space for the tenant. Okay. And so that's what the build out is. So you're going to want, if there's going to be a build out situation, you're going to want to make sure that, a build out allowance from the landlord is covered, the time period for the build out, all of those things are covered in the lease or in the letter of intent. And then again, you may or may not have sophisticated property managers and attorneys involved. And, again, they would be the ones running the ship, steering that ship. So, that's what you got going on with the commercial leases. We're getting close on time, and a lot of what we have here with commercial buildings and vacant lands we've already covered. So I'll be able to go over these last 2 points, but I wanted to stop here and see if there were any other questions or any questions on leases. And again, this is all an overview just so you can have a relatively knowledgeable conversation. I am more than happy to talk to any of you deeper about any one of these things if you're questioned or you have a scenario here in Chevy Chase. So you can always pop in. We'll have a cup of coffee and chat about whatever you have going on, or we can certainly schedule a call or something.
Heather, one thing to note real quick is I know that a ton of times investors call and they're surprised. Is that if you're working with a commercial lease and it's your first time, find out what the lease, what type of payment it is, what type of lease it is, and what does that payment include. I know that sometimes, people will call me afterwards and they want to get out of a lease because they didn't realize the type of lease commercial lease that they had. And all of a sudden the landlord is saying, oh, well, you have to give me this extra payment. That's for like taxes and all these things. So that's something. And then they're like, well, the realtor never told me. And I'm like, well, this is, this type of lease versus another type of lease. So just be very careful. Is it a triple net lease?
Right.
Not, what does that, what does that mean? What about things like, even on a lease is very different to a residential lease, where sometimes in a building, if the HVAC goes, the person who's leasing it has to fix it. So just be aware that every lease, as Heather said, is very custom to the situation. So there are certain things that the person signing it should definitely be aware of.
Absolutely. And, and this applies to all of these types of transactions, except for a resident, investment property using a residential lease. Yes, I'll send a recording. But anyway, for all of these types of transactions, the biggest shock for me when I went from being a commercial title agent and a commercial real estate finance attorney into residential real estate was there are so many rules in residential real estate. And commercial real estate is a little bit like the Wild West. I mean, you can throw a lot of stuff into a commercial lease or a commercial, building transaction. The terms can change at the very last minute. The terms can change at the table. Pricing can change. Loan amounts can change. That can all change the night before closing. You don't have the built-in protections that you have in residential real estate that control the timeframes a little bit more and control the language in the contracts and the language in the leases like you do in residential real estate. So on one hand, it's really freeing and it allows you to be very creative. But on the other hand, depending on the type of person you are, it can either feel very overwhelming, because it's like, well, wait a minute, why is there so much different information in here? So it just kind of depends on what type of person you are. I had a hard time, I've got to say, adjusting to residential real estate and all the rules. I was used to kind of, following my clients' leads and, wherever the transaction went, that was where we ended up. And a lot of times it was very different than what the first draft of the contract looked like. So, all right. So real quickly here, because I want to be respectful of your time here, and we're coming up on 12:50. Again, the commercial building, commercial building purchase is a lot of it's very similar to what I already said about a multifamily building, as far as, you're going to have significant due diligence of the property, significant due diligence on what kind of income is the property generating. You're going to have, the attorneys and the lender really running the show on this one. Once you have that signed letter of intent, and, you're going to have full due diligence review. That's really kind of when you're getting big. And then finally, vacant land, right? It's a land contract. So it's in some instances easier than if there's a building involved. Again, typically if it's vacant land for commercial purpose, it's going to be a full commercial transaction, again, driven by the lender and the attorney. There's going to be much more due diligence in this regarding zoning and maybe environmental concerns, that will change that may change the timing of the property, of the transaction, and the due diligence on the property, because at this point, it may take a little bit longer to get an environmental expert out there to run the environmental testings and get it back, or to get a zoning letter from the county or the city that the property is located in. Those things can take time, and a lot of times they're not timeframes that we as lawyers or you as realtors or real estate agents can control. So, all right, let me stop sharing here so I can see all your smiling faces again, or at least
Can I jump in real quick, Heather? Do you mind?
You sure can.
Cool. So I'm David Badiz. I haven't met some of you, I don't think, but I just wanted to put my name out there. If you ever need help with boots on the ground help, I've been a commercial realtor for about 10 years, and I have access to CoStar, which is kind of the pivotal kind of key element of this, because without access to that, you don't have a lot of information. CoStar is a little quirky and a little hard to use, but more importantly, it's really, really expensive. It's like $500 a month. So I'm happy to share my data with you. We have a little way to get around their login thing. I won't say that far and wide, but among us friends.
Don't say it.
Sorry. But I can help you out. And also, just a couple notes for anyone who's brand new. I don't think you cover this, but if you did, forgive me. There's not really standard forms, as you mentioned, but we have commissioned some forms that we use for both a buyer agency agreement, a landlord listing agreement, and also like a one-time showing agreement, so that you can get your commission protected. And I can share those with anyone who needs help with that. I spent a lot of money on that with an attorney to get that tweaked just right. And then just a couple of quick notes about when you're showing things that I found come up all the time. One of them is when you're listing a property, it has a lot more value if it has a hood. So if it has commercial use as a kitchen, it's much more valuable than if it's just a regular retail space. That's one thing that comes up a lot. And then the other question that may have come up, and I'm not sure if you covered this, is just commission in general. Can you expect the seller or landlord to pay your commission? Yes, in general, but you do have to ask for it. So it kind of works the way that residential does now, where they don't advertise a commission, but they are going to expect you to ask for it. Just make sure it shows up in that contract that's signed between the buyer and the seller, or the landlord tenant, or you won't get paid. And then recently I did a really awesome deal. I was very proud of myself because the landlord and tenant agreed to do like a 6-month kind of trial rental. And if you've done the math on how commission works, it's based on the total value of the lease. So a 6-month lease, even if it's at like 10,000 a month, is not worth a lot, and so your commission is not going to be a lot. And so, in order to protect my commission for when the trial turned into the real thing, I got them to agree, both of them, that we would be paid based on every renewal into the future, period. And usually in commercial, you're only paid for the base rent period for the total of the initial rental period. And you're not paid for the renewals, although it's always negotiable. But you have to remember to put that in there and have your buyer or tenant be on your side on that, because they certainly are not going to fight your fight for you without, a little bit of buy-in. You have to talk to them about it. But that means I'm going to be perpetually paid a commission every time they renew their lease. I think those are the major things I wanted to cover.
That's
Yeah.
incredible.
Amazing.
If you don't mind putting your contact information in the chat, some people wanted to maybe reach out to you. Honestly, guys, this is one of those things that, yes, it's great to have that information, but it might be even better if for the first few ones to bring David in, have him help you, because there are so many pitfalls. I'm glad you brought the contract up. So many people call us and say, hey, I'm going through the SIP forms and I don't find the commercial leases.
Nope.
You won't, because they're all custom. So you want to make sure, and they're really expensive. So you want to make sure to maybe partner up with someone in your office that has the knowledge that will protect not only your client, but your commission as well.
Absolutely. And that was a point I made during our lunch and learn as well, especially for your first couple of transactions. Even if it feels silly, if it feels like, oh, this is just a simple lease, you should always, if you have any iota of doubt or, feel like it's starting to get bigger than what you're comfortable with, you should always partner up with an experienced commercial real estate agent for those first couple, because there are things that this was just an overview. So there are a lot of details that do go into these transactions that an experienced commercial real estate agent will know that you won't. I will say, as far as commercial listing agreements are concerned, either a listing agreement or a buyer broker agreement, Maryland Association of Realtors does have form commercial agreements for listing and for commercial buyer on their website in their forms library. Occasionally, you'll come across a form lease for a commercial lease provided by your broker or through the various associations. But again, you would want to work with an experienced agent or an attorney at that point. And my point, let me give you a quick point on attorneys as well, because a lot of clients, especially if they're just doing a very small lease for a doctor's office or something, they don't want to spend the money on an attorney. They just like, okay, well, yeah, I understand this, sign it and go away. But, especially when it comes to termination provisions and early termination of the lease, and what happens if the practice just doesn't work out or whatever, there are a lot of provisions in there that a layperson who doesn't do this every day, is looking at and may not understand. And so it always behooves a commercial tenant to have an attorney look at the lease up front, even if it's just to look at and point out provisions that might be problematic in the future or more complicated to understand, as opposed to, okay, now I'm in a fight with my landlord because I want out of my lease and I didn't realize I had to pay, a $50,000 lease termination fee, or I didn't realize I had to pay for the lease for, as long as my lease term was supposed to be, if the landlord doesn't get someone in that space. So, I would always advise an attorney to review upfront. And I'm not just saying that because I am one. But really, it's cheaper to have it looked at up front as opposed to have it handled on the back end as a dispute.
Yeah. Heather, that's a great point. And I'll tell you, some of my not so favorite calls that I've gotten lately are somebody didn't realize that the landlord was a big building and that they could be moved to a different, what the
Right.
landlord considered same space, which the, person, who was renting it didn't consider it. I want to make a point about land because we're seeing a lot of land sales. Number one, we do have available for you guys if you want to, if you get someone who wants to do a land deal and you're worried about that seller being fraud, we do have through our underwriter a way to validate them. So just give us your information. We send them a text. They have to validate their ID, and that way you can make sure that everything is being done in advance. The second thing that I'll say is in Maryland, especially, be very careful with land. We have some listing agents that are putting land out there. They're not very familiar with land, and they'll put information out there as to more or less when it comes to acreage and end up selling more than they bargained for. And number two, rollback taxes. A lot of the times, we see where they're buying it, they're not using it, the property was in land use or agricultural use, now it's being bought by your builder, small builder, and all of a sudden they don't realize that they have to pay all these ridiculous taxes at the end. So the more information that you have, the better that you can, assist your clients.
I was actually going to jump in on land as well. Land sounds really simple. It's like land, right? But land is actually probably the most complicated thing you can sell in real estate because of all of the taxes, as you mentioned, but also, zoning and other restrictions, easements, studies. What are the other, if you're developing, you often have like a $40,000 or $50,000 cost to essentially pay back the county for the environmental impact that you're going to put on the land as a result of the development. So whether you're working as a listing agent for land, but especially if you're a buyer's agent for land, and especially if your buyer is a novice, you can get your buyer into big trouble if you are not careful with ensuring that you have somebody knowledgeable representing their interests, whether it's a land use attorney or a colleague or their own internal resources. You should not let a buyer, a novice buyer, just buy a plot of land unless you know exactly what they could do with it.
Yeah,
Absolutely.
that's a
I mean,
great
there are
point.
density restrictions,
Mhm.
just because you live in an area where, just for round numbers, you can put a single family home on a 1 acre lot. This is a 5 acre parcel. Great, I'll build 5 houses. It doesn't work that way. And so, absolutely agree. Get a lawyer. They would need your buyer client would need a lawyer, a good engineer who can, do the drawings and the county submissions and all of that, because the real estate development of a piece of land is like opening Pandora's box as far as all of the different legal requirements that are there. All right. Does anyone else have any questions? I want to be very respectful of time here. I did see in the chat that it was mentioned that Arla has fantastic commercial real estate resources, which I am not surprised to hear because it is a fantastic brokerage. As I mentioned earlier, thank you everyone for joining in. This was, where I spent the bulk of my career. So I'm always happy to talk about commercial deals, corporate law, whatever you want to feel like nerding out about one day, or providing, giving you some advice or reviewing, doing a preliminary review on something for you. I'm always happy to help. Again, we have our virtual mastermind on March 12th. It'll be in our newsletter. I'll throw it in the Arlaverse, where you can register for it. You might even get a phone call from me. You never know. But anyway, it's going to be an amazing mastermind. And I thank you all again very much for coming. And if you have any further questions afterwards, feel free to reach out to us.